was to move people out of institutions and into normal, like family surroundings. These laws came out in about 1972-ish. They specified that if there are 6 or fewer patients or clients living in the house, that is a residential use of the property. That means they're not subject to zoning, business taxes, or any kind of local licensing if there's 6 or fewer, okay? But homes like this, the state licensed homes, are still subject to any regulations that would apply to all the other homes, like parking, like we were just talking about, right? They're not exempt from parking. For the oversight, for the medical places, they're California Department of Healthcare Services. They have the abuse recovery facilities. Those are called SUD facilities now, for substance use disorder. They used to be called AOD, alcohol, or other drugs. They have a website, they have people in charge. If there's a problem with one of these, there's someone we can call. Same thing with Department of Social Services, right? So they have the care facilities. Also, like the juvenile facilities, if you remember the kerfluffle in Ward 3 a couple months ago about the group home going in for the kids, and they're going to have a school and all that, they're registered under the California Department of Social Services. They have a great website. Here's just a quick look at Walden Family Services. They're here in Riverside. They do family care. You see they have a state license. You can tell the date they were licensed. And at the bottom, in blue, it shows all the times the facility was inspected. And you can log on to this, click into it, and see what happened. So the summary for the homes that are subject to state licensing, if it's 6 or fewer residents or patients, that's a residential use of the home. And they're allowed everywhere in the single family zone. We can't stop that, all right? No CUP. But if they have 7 or more residents, then they are subject to local zoning. This is for the licensed facilities, right? Most jurisdictions require a CUP. We do. Here in Riverside, we say, hey, 7 or more, you need to have a 300-foot separation between these group homes and a maximum of 40 tenants. So the 40 tenants, that's a big facility. That's one of the rehab care facilities. You've seen a couple of those around. So even though these homes are subject to state licensing and there's a state inspector that monitors the place, code enforcement and police can still do their thing if the place is causing a problem with noise, trash, parking everywhere, all right? Those laws still apply. Now, sober living homes are more of a gray area. These ones aren't specifically defined in the law. They're not licensed. So generally what they are is a group of people who are drug addicts or alcoholics in recovery, trying to live together kind of communally and stay sober. Now the deal here with these, alcoholics and recovering drug addicts are deemed persons with disabilities under state and federal law. On federal law, it's the Fair Housing Act. You might disagree with the logic behind that, but that's how it is. So they are considered disabled people. And these people, disabled people, are entitled to live together in a family environment in a residential neighborhood. Now, how the treatment progression is supposed to work is if you take your person, your drug addict, off the street, you stick them in a state licensed substance use disorder facility for 30 to 90 days to detox, get their head straight. Those places are very expensive, but there's insurance that'll pay for that. So they stay there for 30 to 90 days. Then they transition to a sober living home, and they'll live there for 6 months, maybe a year, with people like them trying to maintain their sobriety. Then if all goes perfectly, they move into their forever home with a white picket fence, and they have their addictions under control and productive members of society, right? So that's how it's supposed to work. For the sober living homes, in general, there's 2 rules that apply. So one, keep in mind, is that unrelated people can live together as family. All right, this came out of a case called Adamson versus Santa Barbara back in 1980. It was a California Supreme Court decision. So the facts arose in the 1970s. So some of you people could probably remember hippie communes. This place was a hippie commune in Santa Barbara. So this lady named Adamson, she owned the house, this huge house in Santa Barbara, 6,000 something square feet, 10 bedrooms on a 1 acre property. At the end of a cul-de-sac, they had a gate, they had bushes and such. And she had 11 people about her age living with her. And they weren't bothering anybody. Except some of the crotchety Santa Barbara residents said, hey, you kids can't be doing that here. This is a single family residence zone. And we define, in Santa Barbara, we define a single family residence as 2 or more people related by blood, marriage, or adoption, or a group of 5 unrelated people. So the crotchety Santa Barbara people, they got out their cell phones, they used their 311 app, and they reported this house to the city, right? So the Santa Barbara City Code Enforcement goes out there, they tell the Adamsons, hey, you have to stop this, or we're gonna fine you. You gotta kick people out of the house, or adopt each other, or something like that to get around it. It bounced around in court for a few years, and finally the Supreme Court said, hey, the Santa Barbara ordinance defining a family as 2 or more persons related by blood, marriage, or adoption, that violates the state constitution's right to privacy. Because the state constitution has a right to privacy, the federal constitution does not. But the state one is explicit, and the justices said, hey, you have the right to be left alone at home, right? So